Greg Woods teaches criminology, criminal justice, and legal studies courses with the Department of Justice Studies at San Jose State University. A popular educator, internationally respected law enforcement and legal trends expert, constitutional scholar, and student of history, Greg Woods is regularly featured on television, radio, podcasts, and in print, and has presented a number of continuing legal education programs for the Center for Continuing Education. He has taught at the University of San Francisco, Cal State East Bay, Sonoma State, and San Francisco State Universities. He received his Doctor of Jurisprudence from San Francisco Law School and lives and works in the Bay Area. He may be contacted at greg.woods@sjsu.edu.
On November 13th, 2023, in response to increasing public and congressional pressure regarding undisclosed gifts, trips, and financial dealings by several justices, John Roberts, the 17th Chief Justice of the Supreme Court of the United States, announced that the U.S. Supreme Court had published its first ever formal code of conduct. Signed by all 9 justices, the undersigned justices are promulgating this code of conduct to set out succinctly and gather in one place the ethics rules and principles that guide the conduct of the members of the court. For the most part, these rules and principles are not new. The court has long had the equivalent of common law ethics rules. That is, a body of rules derived from a variety of sources, including statutory provisions, the code that applies to other members of the federal judiciary, ethics advisory opinions issued by the Judicial Conference Committee on Codes of Conduct, and historic practice. The absence of a code, however, has led in recent years to the misunderstanding that the justices of this court, unlike all other jurists in this country, regard themselves as unrestricted by any ethics rules. To dispel this misunderstanding, we are issuing this code, which largely represents a codification of principles that we have long rewarded as governing our conduct. Regarding the code of conduct, it codifies existing ethical principles into 5 primary canons. We're going to emphasize these canons as we look to the judicial process to conclude whether or not we are maintaining the integrity and independence of the judiciary. After all, that is the first canon articulated by Justice Roberts and the Roberts Court. Avoiding impropriety and the appearance of impropriety, performing the duties of the office fairly, impartially, and diligently. Extrajudicial activities must be, well, scrutinized. Political and campaign activities must be, well, viewed through this ethical lens. And as we view this American experience, our system through which we dispense justice, through the lens of ethics, over a half a century ago, on October 20th, 1973, that year, The Night the Lights Went Out in Georgia was the #1 song in the country. That's the night that the lights went out in Georgia. That's the night that they hung an innocent man. Well, don't trust your soul to no backwoods Southern lawyer, says the song, 'cause the judge in the town's got bloodstains on his hands. And the Saturday Night Massacre and ethical and constitutional crisis that same year, 1973, October, where President Richard Nixon ordered the firing of Special Watergate prosecutor Archibald Cox. Robert Bork, a former Marine, attorney and law professor, then serving as Attorney General, followed the orders. Bork did so after Attorney General Elliot Richardson and Deputy Attorney General William Ruckelshaus refused to resign. Well, they refused the order, and they ultimately did resign rather than carry out President Richard Nixon's directive to fire the special prosecutor. They contended that the firing of the special prosecutor was politically and legally improper, that it was politically motivated, that it subjugated the judicial process and was, well, unacceptable. The public outrage and political crisis surrounding the firings prompted Congress to enact sweeping reforms aimed at preventing similar abuses of power, enacting the Ethics in Government Act of 1978, a landmark federal law enacted in the wake of the Watergate scandal. It was intended to prevent conflicts of interest and to restore public trust in not only government, but those institutions through which justice is dispensed. It established mandatory public financial disclosures for high level officials across all three branches of the government and created the United States Office of Government Ethics, whether or not we've heard of it recently. Even with the bloodstains on his hands, Robert Bork became federal judge in 1982 when President Reagan appointed him to the United States Court of Appeals for the District of Columbia. Justice depends on the morality of the people and integrity of the process. What follows is a contemporary approach to issues impacting the legal profession in the United States, with emphasis on the California Rules of Professional Conduct, ABA model rules, and canons of judicial conduct. It is an examination of the legal tradition, modern trends, standards of professional responsibility, and approaches to resolve conflict, promote public trust, and improve the access to justice. California is significant because of the tradition, trends, and technology that continue to impact our justice system. Speaking of California, why does California have the most lawyers and New Jersey the most toxic waste dumps? New Jersey got to pick first. That's a lawyer joke. Yeah, okay. Ethics, like lawyer jokes, is a symptom of our culture. The problem with lawyer jokes is that people don't know their jokes. Lawyers don't think they're funny. In perpetuating stereotypes, critical of our culture and legal system, we are reminded that justice reminds us that it depends on the morality of the people and integrity of the process. For more than 2.5 millennia, we inherit a judicial process tempered through time, a process influenced by the development of technology, philosophy, and faith based ideology. Our system through which we achieve justice has evolved in response to the human condition, with standards impacted from time to time by social movements and other natural phenomena that bring change to an otherwise enlightened society. Our behavior is subject to the crucible of cross examination. For more than 2.5 centuries, our system of American jurisprudence has developed to reflect and respond to the best and worst of our collective behavior. William Shakespeare reminds us what's past is prologue. And with each tempest we endure, collectively, we always seem to reflect, reassess, craft legislative solutions with the hope of making ours a more perfect union, consistent with the preamble to our Constitution. We examine here, now, more than 2.5 decades into this 21st century, a trajectory of behavior we can learn from. We must learn from the past and those who have demonstrated themselves with integrity as we engage what awaits us. And I assure you, this is not a hallucination. In Ray Prince Global Holdings et al. That's the case that came before the United States Bankruptcy Court in the Southern District of New York this year, 2026, as I speak to you now. We also learned of this case not through the merits necessarily, but the apology that was then issued by the partner of Sullivan and Cromwell, when the opposition unearthed inaccuracies AI hallucinations. In his apology letter, Andy Dietrich of Sullivan and Cromwell writes to the court, the inaccuracies and errors in the motion include artificial intelligence, AI hallucinations. Hallucinations are instances in which artificial intelligence tools fabricate case citations, misquote authorities, or generate non existent legal sources. We deeply regret that this has occurred. The firm maintains comprehensive policies and training requirements governing the use of AI tools in legal work. These safeguards are designed to prevent exactly this situation. The firm's policies on the use of AI were not followed in connection with the preparation of the motion. In addition, the firm has general policies and training requirements for the proper review of legal citations. Regrettably, this review process did not identify the inaccurate citations generated by AI, nor did it identify other errors that appear to be resulted in whole or in part from this manual error. As he is quite literally falling upon his sword by pointing the blame toward the tool, the artificial intelligence that was supplemented and employed in, well, that legal maneuver in the preparation of the motion, where the opposition, always looking for ways to, well, cast doubt upon the argument of, well, the adversary, they brought this attention to the court. And it was Sullivan and Cromwell that wants to assure the court that the firm's policies governing AI use are both clear and rigorous. Access to AI tools is conditioned on completion of mandatory training. Before any firm lawyer is granted access to generative AI tools, the lawyer must complete two required training modules, completion of which is tracked and verified. The training repeatedly emphasizes the risk of AI hallucinations, including the fabrication of case citations, misinterpretation of authorities, and accurate quotations. It instructs lawyers to trust nothing and verify everything, and makes clear the failure to independently verify AI generated output constitutes a violation of firm policy. The training also requires and reviews those significant consequences of AI related errors in various cases. Now, I would like to conclude that this is happening within, well, let's just say that vacuum of the bankruptcy court. But it's not. This is a symptom of something that is impacting the legal profession. And we look to those law schools who are grappling with ways to, well, help us to better use these new tools. At the University of California, Berkeley School of Law, there is an effective policy. It's brand new, and we need to pay attention to it. According to the University of California, Berkeley School of Law, future lawyers may need to use artificial intelligence, AI, fluently. But the current state of technology requires that AI use be coupled with the cognitive skills necessary to strategically deploy the technology, to critically assess its work product, and to uphold ethical obligations to clients and to the legal system. Cognitive functions are diminishing. We should be concerned. As Professor Chris Hufnagel, faculty director of the Berkeley Center for Law and Technology and a principal author of the policy, he reported AI models can, in effect, write a research paper, soup to nuts, and that capability required us to rethink students' reliance on them. Or, as we consider the Sullivan and Cromwell apology letter, all attorneys must be, well, critical of the way they use and how the tool is used in the reference toward those obligations that they have before the court and for the public trust. Professor Hofnagel continued that the school concluded its 2023 AI policy had been too liberal given how far AI generative models had advanced. Are we using or being used by the tools we deploy? Ultimately, it is in the way the tools are used that will determine their legitimacy. Meta, well, Facebook, and AI smart glasses, a brand new product. It's a Ray-Ban Wayfair style sunglasses that automatically inserts the ability to have those computer processing applications be at command without anyone really knowing while you are interacting socially. It's Meta and AI smart glasses that have been banned in courtrooms. There are flock safety cameras, automated license plate readers that are being debated as we record this message today. Cities like Mountain View, California, and other cities across the country are opting out of their contracts to reevaluate how this technology is deployed. From Los Angeles Superior Court, the first social media addiction case to reach a jury. KGM versus Meta et al., that includes YouTube, Google, and other social media providers. From the Los Angeles Superior Court, Meta and Google, well, Facebook and YouTube, were found liable for intentionally designing addictive algorithms that severely harmed a young woman's mental health, awarding millions in compensatory and punitive damages. Meta was deemed 70% responsible, Google 30%. Plaintiff, Kaylee, we will call her, began using YouTube at age 6 and Instagram at age 9. Exposed to near constant social media use as a teenager, she became controlled, zombified, prone to depression and self loathing. The court found this to be a predictable result of deliberate design choices made by the platforms. The lawsuit claims the harm was foreseeable and intentional, that Meta and YouTube made deliberate engineering decisions to maximize engagement among young users for advertising revenue, and that they knew those decisions carried mental health risks. Like the tobacco industry before it, big tech is receiving similar scrutiny, heavily investing in artificial intelligence with hardware infrastructure and autonomous AI agents at the forefront of their operations. Courts are not immune to the near constant connectivity either. Over the past decade or so, our courts, commerce, and communications systems have undergone similar adaptations. Perhaps for purposes of efficiency, new tools are now integrated to streamline the process of judicial economy. At what cost? Our culture has undergone a transition through the pandemic era to the present. We've undergone some undeniable technical integration in all aspects of life, including our methods of social interaction, platforms for communication, and in our pursuit of justice. Tools for advancement, tools from Silicon Valley, California. The tool itself is neither bad nor good. The ethical implications are in the deployment, like a hammer or a firearm or a keyboard or the law. It depends on the way the tool is used. As we speak, the Pentagon is demanding that Anthropic lift its usage safeguards on its AI model, Claude, allowing the military unrestricted use for all lawful purposes. Anthropic has refused, maintaining two firm boundaries, ethical boundaries. Its technology must not be used for fully autonomous weapon systems or the mass surveillance of citizens. It is the producer, Anthropic, that sees a dystopian police state in our future, and perhaps the surveillance drones that are deployed, supplementing the tools of law enforcement and investigations, unregulated data sharing for both legitimate and illegitimate purposes, AI used for mass domestic surveillance and fully autonomous lethal weapons. Well, we should consider that as we think about our military expeditions throughout the globe and what is happening domestically. Mass surveillance fears, people tracked and profiled, social media activity, pre-trial, during trial, immigration enforcement worries, fears of law enforcement by, well, executive order. Like the services of an attorney, we seek justice when we need it, not a system that is conditioned to bypass that judicial process by way of executive order. We insist those practitioners operate with moral character to bring justice. We look to those who know the law. We look to the law to deliver justice. As we will discuss, law is a moral phenomenon. It requires virtue. The people must be good, so that we might have truth, transparency, and trust to preserve the integrity of the judicial process, to promote the dignity of the profession, to increase the public's trust through truth, transparency, and trust. For there to be equal justice under the law, we seek truth through the judicial process. Transparency and accountability bring trust. Truth, transparency, and trust. But first, a lawyer joke. How do you know when a lawyer is lying? Their lips are moving. Now, some of you might not think that that's funny, not a joke at all. Advocates to navigate the judicial process remember truth, transparency, and trust. We must trust the process and the people to do the right thing. Today, well, as we will discuss, we're not slouching. There is no slouching allowed. We'll be reviewing a tradition of ethical decision making so that we'll understand how good overcomes the bad. And it begins with the oath to follow. As we think about the oath for attorneys, it's far more than lip service, more than a pinky swear to do good. But if that kind of ritual helps you to appreciate the magnitude and sacred significance of the task for those who've chosen it, the attorney's oath is taken before a judge or a court. In California, the state bar provides an example similar to every jurisdiction in the United States. Specifically, I solemnly swear that I will support the Constitution of the United States and the Constitution of the state of California, and that I will faithfully discharge the duties of an attorney and counselor at law to the best of my knowledge and ability. As an officer of the court, I will strive to conduct myself at all times with dignity, courtesy, and integrity. Support the Constitution as an officer of the court with dignity, courtesy, and integrity at all times. Justice depends on the good moral character of the people who practice law by preserving the integrity of the process through which it is dispensed. Practitioners' conduct and that of their team members is regularly subject to scrutiny. The California Business and Professions Code, Section 6068, provides in part, it is the duty of an attorney to support the Constitution and the laws of the United States and of this state, to maintain the respect due to the courts of justice and judicial officers, to counsel or maintain those actions, proceedings, or defenses only as appear to him or her legal or just, except to the defense of a person charged with a public offense, to employ, for the purpose of maintaining the causes confided to him or her, those means only as are consistent with truth, and never to seek to mislead the judge or any judicial officer by an artifice or false statement or fact of law. Objectively, in the interest of justice, we must be aware of the ethical issues of our time. Subjectively, to increase awareness of the potential for harm and how to protect ourselves, to resolve conflict, promote justice, and to maintain our personal lives, to be beyond reproach, impervious to harm. We refresh our files from antiquity. We can conclude that ethics is knowing right from wrong and choosing to do good. And as we take a deep dive to better understand this place of ours, we inherit a long tradition of preferred behavior, codified from way back. We can go back 2.5 millennia to Aristotle, the Nicomachean Ethics, Book 1 of 10. Well, the first sentence is clear. Well, for those of us who might spend time trying to pore over the thoughts of those who came before us. Every art and every inquiry, and similarly every action and pursuit, is thought to aim at some good. And for this reason, the good has rightly been declared to be that at which all things aim. Where to begin? I guess we can begin with the Bronze Age. From hunter gatherers to the establishment of the city state. Though evolved as it has, in many ways our legal system is rooted in the sophistic tradition of ancient Greece. The peripatetic professional teachers of ancient Greece, tutoring those who could afford their fees for the services rendered, teaching subjects like philosophy, rhetoric, virtue. From the 1989 movie, Bill and Ted's Excellent Adventure, we have 5 words: be excellent to each other. It's easier said than done. In the movie, a work of fiction, I may add, Bill and Ted travel back through time to meet Socrates, or as they pronounce it, Socrates, as he is referred to in the movie. Of course, sophist has a dual meaning, the opposite of virtue, winning by any means necessary. It was Socrates who was critical of the sophists for just that reason. We go back a quarter century. We remember the contributions of one Al Davis. He said, just win, baby. That's the NFL owner from the Raiders way back in 1984 following the Super Bowl victory. How many lawyers does it take to represent an NFL football player? A dream team, of course. It was Al Davis, rest in peace, who was owner of the Raiders, who famously or infamously dreamed of victory by any means necessary. And we might ask ourselves, at what cost? Well, you can look up the name Lyle Alzado. You will see all kinds of warriors on the gridiron who have paid the ultimate cost, who became the face of perhaps all that is wrong with professional sports. The Raiders have long since, well, relocated from their home in Oakland, California, moving to Los Angeles, moving back to Oakland, and, well, recently relocating to Las Vegas. They say what happens in Las Vegas stays there. Maybe that's true. As a 49ers fan, I'd like to conclude that perhaps there's some truth in that notion. But we think about the contributions of professional sports and whether or not we can believe what our eyes are, well, viewing, whether or not the outcome has been predetermined through betting, sports book, the delegitimacy of professional sport. Does merit matter? Is there a proper way to win? Is winning the same, just as the outcome is the same? Is the winning and the outcome, does it matter? Does the means justify the end, or does the end justify the means? Critical of sophists, we can attribute the pejorative meaning not only to Socrates, but really anyone who confronts those individuals in a courtroom, those legal practitioners who, well, behave in very much the same way. We can conclude that it was Socrates who, well, of course, taught and influenced Plato, who taught Aristotle, who was paid by King Philip of Macedonia to teach his young and exceptional son, Alexander the Great. Aristotle wrote about ethics, including perhaps his most famous work, Politics, in 350 BC, where he illustrates the power of the state and provides justifications for the total rule of some humans over others. And from the Nicomachean ethics, we have the golden mean. We have notions of virtue for the first time. And if we think about Western civilization and where it is we have crafted these notions, the golden mean, well, that's really an articulation against extremism, where we might have some middle ground, where we want to be reasonable in the way that we might approach justice. And we can conclude that the golden mean is distinct from the golden rule. Sure, from the faith-based system, this notion of treating others as we want to be treated, do unto others as yourself. We might conclude also that the golden rule, with all of its pejorative notions, could quite literally mean that those with the gold make the rules. But if we can cling to Aristotle's notion of virtue, being good, and how good will make us happy, we can then have a foundation from which we ourselves might be, well, the most satisfied with this judicial process. As we are contending with the sophists who taught wealthy people how to win arguments, regardless of whether their arguments were actually ethical, factual, or true, a castigation of the legal profession that continues to ring true, not through excellence, but by being deceptive, misleading. Arguments and the court, well, those with whom they were engaged were ultimately misled. They achieved victory by any means necessary. Again, I ask, does merit matter? Why be excellent? Why are there so many lawyer jokes anyway? Stereotypes that focus on the flaws of a fractured legal profession. Public servants or self-serving sharks swimming the chummed waters, hoping for deep pockets. We look to Immanuel Kant, who helps us to better understand deontological ethics, where he wrote way back in 1785 in his groundwork of the metaphysics of morals that we should act according to that maxim whereby you can at the same time will that it should become a universal law. So, what happens if everybody does what it is that, well, we are choosing to do? Would the world be a better place? Would we compromise the integrity of the judicial process? Or, as we will see in regard to those uh, rules of professional responsibility, whether or not we are subjecting ourselves to discipline, deontological ethics. It's the duty to do the right thing by being good. A righteous step in a path will ultimately bring a righteous result. Each step in the pathway towards justice must be righteous in order to achieve a righteous result. Now, this is distinct from the teleological ethics, by any means necessary, the ends justify the means, where our excellence is, well, based solely upon our victory, instead of how it is that we achieve that. In our time, we hear the term lawfare to identify the use of legal systems, courts, and legal proceedings to achieve strategic, political, or military objectives, essentially weaponizing the law against an opponent. Our culture is reflected in the law. The more we examine and respond to the bad behavior of others, the more we can learn about our own flaws. Our culture evolves through time, like our law. It magnifies, amplifies, and exaggerates our flaws. So, how many lawyers does it take to screw in a light bulb? None. They like to keep their clients in the dark. Another lawyer joke? We'll keep it light. Justice depends on transparency and accountability to promote public trust and dignity of the profession. In 1886, perhaps at the conclusion of that industrial revolution that was not only permeating Europe, but also contributing to the development of the United States and what we have inherited now in the 21st century, we can go to the end of that 19th century, where we are introduced to the words of one Friedrich Nietzsche, beyond good and evil. He who fights with monsters might take care lest he thereby become a monster. And if you gaze long enough into an abyss, the abyss gazes also into you. So, who fights the monsters exactly? Who delivers justice to those who've been harmed by monsters? Who holds the monsters accountable? Consistent with Nietzsche's observation, is there a deleterious impact on those who do? For those who work in criminal courts where the monsters are judged, visiting clients in jails and prisons where the monsters are caged, for those who work in family court where the emotion is charged, for those who work in the juvenile court where delinquency is not only corrected, but presumed to be inherently salvageable. Are monsters salvageable? I'd like you to read the 2009 book Dreams from the Monster Factory, a tale of prison, redemption, and one woman's fight to restore justice to all by Sonny Schwartz. Restorative justice is easier said than done. For all who find themselves within the safety and security of the four corners of a courtroom, where personal and pecuniary interests are pursued and justice dispensed, we must step back from Nietzsche's abyss and all that's evil by distinguishing good from bad, in perfecting our own moral compass to obtain the righteous result. We must remind ourselves of the righteous path, like medieval knights defending the faith from whatever faith-based system you employ. We communicate, we commit to ourselves and each other to support and defend the Constitution. From the categorical imperative to the constitutional imperative, we bring remedy, restoration, and relief by operation of law. So we must focus on what it is that we hope to respond to: moral turpitude. While the ABA has moved away from this term, as uh, ancient as it might seem, numerous state jurisdictions like California still retain moral turpitude as a specific statutory standard for lawyer discipline. In the context of judicial canons, moral turpitude refers to conduct that is inherently base, vile, or depraved, and contrary to accepted social standards of honesty, justice, or morality. While not explicitly listed as a single phrase in ethical codes, it acts and it describes those acts that are involving moral turpitude as directly violative of our core judicial canons by severely undermining the public confidence in the judiciary. To that end, we have the California Rules of Professional Conduct. We look to the Business and Professions Code, the aforementioned attorney's oath, and our Rule 8.4, specific to misconduct, consistent with the ABA rules of misconduct, Rule 8, and the comments that follow. California Rules of Professional Conduct 1.0. The purpose and the function of the rules of professional conduct is that they are intended to regulate professional conduct and lawyers through discipline. A willful violation of any of these rules is basis for discipline. From the comment, we have the rules of professional conduct explained as being intended to establish the standards for lawyers for purposes of discipline. Therefore, failure to comply with an obligation or prohibition imposed by a rule is a basis for invoking the disciplinary process. While the rules are intended to regulate professional conduct of lawyers, a violation of a rule can occur when a lawyer is not practicing law or acting in a professional capacity. The California Business and Professions Code, Section 6106, it identifies moral turpitude, the commission of any act involving moral turpitude, dishonesty, or corruption, whether the act is committed in the course of his relations as an attorney or otherwise, and whether the act is a felony or misdemeanor or not, constitutes a cause for disbarment or suspension. If the act constitutes a felony or misdemeanor, conviction thereof in a criminal proceeding is not a condition precedent to disbarment or suspension from practice therefore. The State Bar of California defines a crime of moral turpitude in the moral character context. Crimes involving moral turpitude include, but are not limited to, fraud, blackmail, forgery, robbery, burglary, theft, illegal use of a credit card, and other financial crimes, possessing or transporting stolen property, domestic violence, sexual assault, or other crimes involving dishonesty. Justice depends on transparency and accountability to promote public trust and dignity of the profession. The term misconduct is used both in the Rules of Professional Conduct Rule 8.4 and the ABA Rule 8.4, maintaining the integrity of the profession, where it is professional misconduct for a lawyer to violate the rules of the State Bar Act, knowingly assist, solicit, or induce another to do so, or do so through the acts of another, commit a criminal act that violates adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects, engage in conduct that is prejudicial to the administration of justice, state or imply an ability to influence improperly a government agency or official, or to achieve results by means that violate these rules, the State Bar Act, or other law, or knowingly assist, solicit, or induce a judge or judicial officer in conduct that is a violation of an applicable code of judicial ethics or code of judicial conduct or other law. For purposes of this rule, judge and judicial officer have the same meaning as in Rule 3.5 sub c. The ABA Rule 8.4 continues with sub G, to engage in conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, material status, or socioeconomic status, in conduct related to the practice of law. This paragraph does not limit the ability of the lawyer to accept, decline, or withdraw from a representation in accordance with the Rule 1.16. This paragraph does not preclude legitimate advice or advocacy consistent with these rules. We can read the rule, we can better understand the rule, for it is a foundational understanding dictating that attorneys are subject to discipline for dishonest, deceptive, or prejudicial conduct, even when acting in a professional capacity or attempting to bypass the rules by using a third party. So, how many lawyer jokes are there? Well, there's only three. The rest are true stories. As we look to judicial integrity, we can conclude that we have a number of individuals whom we might emulate in spite of the tough decisions they have made. Earl Warren, 14th Chief Justice of the Supreme Court of the United States from California, he so succinctly stated during his tenure with the Warren Court, also giving his name to legitimize the investigation into the assassination of the President of the United States. He stated around that time in 1962, in civilized life, law floats in a sea of ethics. Each is indispensable to civilization. Without law, we should be at the mercy of the least scrupulous. Without ethics, law could not exist. Without ethical understanding, the law, as a ship of state, would be stranded on dry land. The likes of Earl Warren, exercising constitutional authority through state action to reach people within the statutory scope of the law. Our Constitution provides, through the separation of powers, it is an independent judiciary charged with the task to check and balance those powers, not to blindly follow the orders, but to scrutinize the judicial process, empowering legislators to craft solutions that address our societal problems. Laws enforced by the discretion of the executive, well, even though we experience them regularly, we officially conclude that that's not the best approach towards justice, that our laws must be subjected to the scrutiny of judicial review as they are crafted or enforced. Solving problems by looking backwards in time, stare decisis, to stand by things decided, precedent, resting on precedents instead of fashioning new solutions, as it always has been. Notions of justice may be swift or smack of a glacial paced process, perhaps taking forever to conclude, favoring those with the resources, backroom deals, extrajudicial influences, conflicts of interest, presumptions of nepotism and an old boys network, the appearance of impropriety. We have to learn to become better. And we can learn to become better by focusing on those individuals with whom we have produced, who have distinguished themselves. Perhaps he was looking for atonement for his time as governor of California, or the attorney general of California, or the district attorney of Alameda County during the Great Depression and World War II era, where there was an executive order 9066 to, well, hold those Japanese Americans in internment camps. And this all happened under the watch of Earl Warren. In that era, the court was filled with men with broad and extensive public service, rather than simply experience on a court of appeals. The justices were able to write their own opinions rather than delegate them to, well, their law review alumni or artificial intelligence. We look to those courts, those packs of people packed by the executive, Franklin Roosevelt. And in response to that, well, Harry Truman, President Truman, perhaps the most ethically charged decision in all of human history to drop the atomic weapons on what would otherwise be civilian populations of Hiroshima and Nagasaki. Well, we do harm to make good. We kill because killing is wrong. We have conundrums that we must grapple with. These ethical notions of how it is that we might be able to, well, employ utilitarianism. Jeremy Bentham, the notion that, well, the best solution is one that satisfies the most people, to work more harm than good. And if killing is bad, by killing, maybe we are stopping the greater killing, but philosophically, we might conclude that both sides of our mouth are not, well, consistent. The Stone Court refers to the Supreme Court of the United States from 1941 to 1946. It was Harlan Fiske Stone who served as the 12th Chief Justice until he died in office, followed by Fred Vinson. Fun fact, Harry Truman, the last Democrat to nominate a Chief Justice of the Supreme Court, that was the 13th Supreme Court Justice, Fred Vinson. Intense friction between constitutional civil liberties and wartime national security. It issued several controversial readings and rulings and interpretations with broad government and military powers. We might conclude that Shelley versus Kramer, the case that undoes much of the harm through the enforcement of racially restrictive covenants, that 3 out of the 9 justices on the Supreme Court had to recuse themselves from this case, well, because they all owned real property that contained the racially restrictive covenants. The 13th Chief Justice of the United States, Vinson, dies in office, heart attack at age 33, not from California. But then it sets the stage for Dwight Eisenhower to name Earl Warren. He precedes Warren Earl Burger, which then set the stage for Chief William Rehnquist and the John Roberts course that we have today. If we think about the court of John Roberts, we still have to look backwards at time through these individuals who have come before, as they have set the stage and they have created the precedent. And if we think about those canons of judicial conduct, we have to look to the California Code of Judicial Ethics, the Code of Conduct for the United States judges, and the aforementioned Code of Conduct for justices of the Supreme Court of the United States. The California Code of Judicial Ethics, Canon 1, a judge shall uphold the integrity and independence of the judiciary. Canon 2, A judge shall avoid impropriety and the appearance of impropriety in all of the judge's activities. Canon 3. A judge shall perform the duties of judicial office impartially and diligently. Canon 4. A judge shall so conduct the judge's quasi-judicial and extrajudicial activities so to minimize the risk of conflict with judicial obligations. Canon 5. A judge or judicial candidate shall refrain from inappropriate political activity. Canon 6. Compliance with the Code of Ethics. The Code of Conduct for the United States judges elaborates on these concepts, specifically, Canon 1. A judge should uphold the integrity and independence of the judiciary. An independent and honorable judiciary is indispensable to justice in our society. A judge should maintain and enforce high standards of conduct and should personally observe those standards so that the integrity and independence of the judiciary may be preserved. The provisions of this code should be construed and applied to follow that objective. And also, Canon 2, a judge should avoid impropriety and the appearance of impropriety in all activities with respect for the law, those outside influences, and non discriminatory membership in those groups that might very well conclude on the basis of race, sex, religion, or national origin. Well, what is it that Groucho Marx said? That he would not want to be a member of any organization that would not welcome him with open arms. The court of public opinion has always served to scrutinize and pass judgment on high-profile examples of bad behavior. More than scoffing at lawyer jokes, inventing terms to judge the judges, we can look back to, well, 1987 and Judge Robert Bork, who became a verb during the Supreme Court nomination. Some say the quid pro quo in response to that agreement he made with once President Richard Nixon, as he had the blood on his hands from the Saturday Night Massacre. It was at the time of his Supreme Court nomination that California Senator Barbara Boxer expressed her aversion to turning a person's name into a political weapon. Dictionaries like the Oxford English Dictionary defines the verb bork, well, as slang, to defame or vilify a person systematically, especially in the mass media, usually with the aim of preventing his or her appointment to public office, to obstruct or thwart a person in this way. We look to the example of Robert Bork, contrasting his example with that of Earl Warren, and we can conclude that there are two distinguishing characteristics. Yes, they both had an allegiance to the Republican Party. But as we ask ourselves whether or not Earl Warren performed as was predicted by the executive at the time, specifically President Eisenhower, whether or not Bork also, well, performed as predicted in regard to the Saturday Night Massacre and what it is that not only President Nixon, but subsequently President Reagan hoped to accomplish by naming Judge Robert Bork to the Supreme Court. He never got to the Supreme Court. He, well, retired. He wrote a book in 1996, Slouching Towards Gomorrah, a play on words from the William Butler Yeats poem, changing Bethlehem to Gomorrah. For those of us who are studied in the faith-based system, we know that Gomorrah is the location of debauchery, moral turpitude, whereas Bethlehem is the designed and decided and calculated place to begin such a faith-based system manifest into the physical world. The title and phrase serves as a metaphor for societal decay and moral decline, particularly in the United States. 3 decades later, his book, imperfect as we all are, in its castigation of progressive trends, is remarkably fresh for our time and purposes here. He wrote in chapter 6, the first sentence, a nation's moral life is, of course, the foundation of its culture. Consider Professor Hufnagel and the AI policy from the University of California, Berkeley School of Law, consistent with the apology letter from Sullivan and Cromwell. Have our policies become too liberal? Are we slouching? Do we require discipline? Can we be good without it? Today, we're not slouching. There is no slouching permitted. We must insist on ethical decision making to follow and apply the law, to resolve conflict and bring about justice, to commit to the highest standard of professional responsibility so that the good overcomes the bad, to make ours a more perfect union. Transparency and accountability bring trust. Trust through transparency. We have truth, transparency, and trust. This has been an examination of our legal tradition, modern trends, and standards of professional responsibility. We inherit a tradition of ethical decision making in the California Rules of Professional Conduct, the ABA Model Rules, and canons of judicial conduct, including the Code of Conduct for Justices of the Supreme Court of the United States as recently as 2023. Justice depends on the morality of the people and integrity of the process. To commit to the highest standard of professional responsibility, the Constitution demands it. We must insist on it. For the Center for Continuing Education, I'm Greg Woods.